Welcome to this video for the Scottish Law Commission. My name is David Bartos and I'm a Commissioner at the Commission. First of all, can I say a few words about the Commission for those of you who are not familiar with it? The Scottish Law Commission is an independent body. Our job is to look at Scots law and see whether there are rules of Scots law that could be modernised and made fit for today's world. In this particular instance, we've been looking at the law that applies to commercial leases, and in particular to certain types of commercial lease. At the end of our review project, we will be making recommendations to the Scottish Government for changes in the law. What we are interested in is what you make of our proposals. And at the end of this video, I'll be asking you to give your thoughts on what the law should be. So let's have a look at the law that we are looking at. It's the law that applies at the end of a commercial lease. That's a lease to a business. There are many of these sorts of lease. For example, there could be a lease of a shop, such as this one, a small shop. There are many hundreds, thousands of them up and down Scotland. Alternatively, the lease could be of a larger retail unit, such as one that is found in retail parks. Again, there are many of these in Scotland, particularly in urban areas. Alternatively, it could be the lease of a cafe or lease of a takeaway business, or the lease of a pub or restaurant. Hair and beauty businesses are very common, and many of them lease their premises. If the lease is a premises for that type of business, then again, that is something that we are looking at. So, what is our particular concern? What we're looking at is what happens when the lease nears its end. So, for example, the lease might have a provision in it, such as the one on the slide. Term and rent. In consideration of the rent and other provisions of this lease, the landlord lets the premises to the tenant for a term starting on 1st October 2019 and ending on 30th September 2024. And so as the 30th of September 2024 comes into view, the question for both landlord and in particular for the tenant will be, what happens when that date comes about? What will happen to the business? Will it need to leave the premises or can it stay? And that's particularly important for high street tenants of smaller units. There are a number of options for these sort of businesses. Either the lease could be renewed if the landlord agrees. Alternatively, the tenant could find other premises. That might or might not be straightforward. In certain rural areas, it might be more difficult. In some urban areas, perhaps easier. We've all seen to let signs up and down the streets of Scotland's towns and cities. If there are difficulties in finding other premises, and that's the only premises from which the business trades, then there is the threat of closure. So, what does the law do about this at the moment? The answer is to be found partly in the Tenancy of Shops Scotland Act 1949. And this gives the tenant an option of seeking a renewal of their lease for a maximum of 1 year. That act gives that option, provided that renewal is reasonable in all the circumstances. Now, what is renewal in all the circumstances? Is it reasonable for the landlord, reasonable for the tenant? And how are the interests of the landlord and tenant to be balanced up? That's had both landlords, tenants, and their agents scratching their heads, and their legal advisors too, which is not good when the tenant or landlord seeks legal advice. And matters don't stop there. The renewal is granted by the court, the sheriff court. So the tenant actually has to go to court in order to obtain the renewal from the sheriff. With any court application, there are difficulties. First of all, there's the cost. Then there's the time and delay in having the matter resolved by the court. That's time and delay that could be used either to find new premises or, from the landlord's point of view, to find a new tenant. And last and not least, there's the uncertainty of going to court. We've already seen how difficult it is to know what is reasonable. So when all these three factors are taken into account, it's not surprising that business owners of the high street units we've just looked at tend not to be able to take advantage of the 1949 Act. Instead, the only businesses that seem to be able to take advantage are the retail park tenants. But of course, for them, their businesses are much more able to absorb the loss of a unit. That's something that's not available for the small businesses for whom this Act was originally intended. So at the Law Commission, we've looked to see at what can be done about this situation, and we've come up with four options. One of which, the one at the very bottom, is simply to keep the Act as it is. But we don't think that's a particularly good option. And so we've come up with three alternatives. First of all, we could have the Act repealed and not replaced. It would simply be taken off the legal statute book. Secondly, we could have it repealed and replaced with new rules for tenants of the retail, pub, hair and beauty, food and drink, hospitality leases we've been looking at. Thirdly, the Act could be kept, but reformed in order to make it more user-friendly and cheaper. So let's have a look at these options in a little bit more detail. Looking at the first option, no special treatment, repeal of the Act and not replace it. The idea here is that these retail leases and leases of pubs and the other businesses that we've looked at don't need to have any special treatment different from that which applies to offices, for example, or industrial units, or leisure premises such as gyms. Simply one rule would apply to all of them, and that rule is that there would be a 3-month notice to quit requirement, whereby the tenant would be given 3 months warning that the lease is about to end. But that wouldn't apply in all cases. Indeed, in many cases, it might be the lease itself could exclude any notice to quit or any warning. And in that case, if these rules applied, then a tenant might be left without any indication of what the landlord's intentions are up until very close to the end of the lease. Another option is to ensure that the tenant gets a compulsory warning. So under this, the 1949 Act would be repealed, but it would be replaced by special rules that would apply to these retail and other leases. Specifically, the notice to quit, the warning from the landlord to the tenant that the lease is about to end, would become mandatory, compulsory, irrespective of what clauses, such as no warning clauses, there are in the lease. Another issue under this particular option is what the warning should be. As we've seen with the office, industrial unit and leisure leases, the default rule is 3 months, but there's an argument that it should be longer for these retail leases if there are special rules. 6 months has been suggested. The third option is a reformed 1949 Act, so the court-based remedy of asking for a year's renewal would remain, but we would clarify the criteria. So, for example, because the 1-year renewal is really designed to assist a small business, we would keep entitlement to small businesses. For example, those employing 10 employees or less and having less than 316,000 or so net assets. That would be a gateway test. In addition, the legislation would state a statutory statement of objects. So in other words, the court would look at what the purpose of renewal is in order to decide whether it's reasonable. And what the purposes that we have in mind are things like saving a business from closure, or to allow the conclusion of negotiations between landlord and tenant. And finally, we think a couple of measures can assist the cost issues in this process. First of all, mediation, whereby the parties have to come together and discuss renewal prior to any court proceedings, could be introduced and made compulsory. And in addition, if the case did ultimately go to court, then court costs, which at the moment can be very high, could be capped. And as we've already noticed, one of the options is just simply to keep matters as they are. But that seems to us unsatisfactory. You may or may not have other ideas. And so we come on to you. How can you give your views on our options? Well, we have a website, www.scotlawcom.gov.uk, which you can go to, and there you will find a response form. The response form is quite lengthy, but you don't need to answer all the questions. What's important is the very last question, question 81, and it's a question where you're asked to express your preference between the various options that I've just outlined. More details of those options are given in our discussion paper, which is on the website. But ultimately, what's needed is your views on the order of preference of the options, which ones you'd like most and which ones least, and why. The deadline is the 31st of July 2024, and we look forward to hearing from you. I hope that you have found this of interest, and if there are any questions, please don't hesitate to contact the email contact on the website. Thank you very much. Bye for now.